Hi, I'm Blackbright. Welcome to my channel. First time you're passing through, thanks for stopping by. You can subscribe, you can share, you can like. And for my existing subscribers, thank you for sticking with me. I just wanted to, I know I've done a video like a little bit like this before about deprivation of citizenship on the quiet, but when I did that one, the Home Office had to notify the person who was being deprived of the citizenship. Now they don't have to do that. They've slipped in a new amendment to the immigration rules, and now they don't have to make any attempt at all to notify anyone who has been stripped of their citizenship. And it can be for, well, it is it's meant to be for something really serious, but it's relative really, because you can be sued for fraud. Now, when you think about fraud or misrepresentation, so they're thinking about Shamima Begum, which is why this amendment has been brought in, because she travelled on somebody else's passport. But ordinarily, it's been extended so that even supposing you've done something wrong, this is in an extreme case. You've done something wrong on your application form. You've put something incorrect on your application form. That could be rendered as fraud. Fraud is one of the reasons you can be stripped of citizenship or misrepresenting someone. So it's not difficult to be stripped of your citizenship when you look at it from that perspective. I mean, if the Home Office want to be pedantic, they could take up any error on an application form and deem it as fraud. So, and also, it's a bit vague. Another reason why you can be stripped of your citizenship is if it's not conducive to the public good. Now, the public good is based on your character, your behaviour. I mean, isn't that relative? I mean, it is supposed to be associated to national security, but even that is relative. Anyway, what I decided to do, the source is Free Movement UK. I've decided to read it because it's technical. I just gave you a little blurb in the front so you can get an idea of what I'm saying when the words get a bit complicated. Okay? The Home Office can take away anyone's British citizenship when it would be conducive to the public good. But would that not make the person stateless? She can also take away naturalised citizenship if obtained by fraud, false representation, or concealment of a material fact. So that means lying by omission. If you've missed something important on your form, even that can be a reason for you to be stripped of your citizenship. The circumstances in which the Home Secretary has exercised this power for the public good have largely concerned Brits who travelled foreign countries to join Islamic terrorist groups. The power has had the practical effect of preventing them from re-entering the UK, meaning they do not become terrorist threat on domestic soil. The government is now about to change the law so that people will no longer need to be notified about being stripped of their citizenship. So before, when it was to do with Shamima Begum, I think her appeal is not going to be until November 2022. But anyway, so this is where all of this stems from. So NC19 is the no notice citizenship deprivation. That means they don't have to give you any notice. You can be walking along thinking you've got your citizenship and it's been stripped, and you don't know until you leave the country and try to come back in. So today, that came today. The Free Movement came out today. So today, MPs are expected to vote in committee on Amendment NC19 to the Nationality and Borders Bill 2021. NC 19 would create some circumstances in which the Home Secretary does not need to tell the person being deprived of their citizenship what is about to happen. At present, Section 40 in brackets 5 of the British Nationality Act 1981 provides that the Home Secretary must give written notice to a British citizen before they have their citizenship taken away. The British Nationality in brackets General Regulations 2003, as amended in 2018, allow for notice to be sent to the person's last known address if their whereabouts are unknown. But the recent High Court decision in R in brackets D4 versus Secretary of State for the Home Department 2021 found that the 1981 Act did not permit the government to make no effort whatsoever to contact someone before depriving them of citizenship. The D4 judgment is currently awaiting an appeal hearing. NC 19 is an obvious attempt by the government to decide the notice issue outside the courts by changing what the 1981 Act says. It would put in a new subsection 40 in brackets 5A into the 1981 Act. And you know, the other day when I was saying people, they don't know when these acts change, when the law changes. How are people supposed to know? And I'm thinking about the Windrush here and all of that kind of stuff. This would allow the Home Secretary to ignore the written notice requirement in subsection 40 in brackets 5 in the following circumstances. So now they can ignore giving notice in these circumstances. A, the Secretary of State does not have the information needed to be able to give notice under that subsection. B, it would for any other reason not be reasonably practicable to give notice under the subsection, or notice under that subsection should not be given in the interest of national security. That was another option. In the interest of the relationship between the United Kingdom and another country, or otherwise in the public interest. The perceived advantages of not giving notice appear to be threefold. First, it avoids a deprivation order being unlawful if incorrectly communicated to the affected person. Second, there may be other public interest reasons for not communicating notice, in brackets, or seeking to communicate at all, close brackets, with the person concerned, particularly if they are deemed a national security risk. And third, not giving notice bolsters a public narrative that the government is doing whatever it takes to keep Britain safe. So in a nutshell, they don't have to give notice anymore. And they've given out these 4 or 5 different reasons, circumstances when they don't have to give notice, but it's all overridden by the fact that notice under subsection should not be given. So they don't have to give it anymore. The perceived advantage, sorry, I've read that. Have I? Yeah. So why exactly is NC 19 concerning? NC 19 is the no notice of deprivation. There are 3 reasons why this provision is concerning. First, it is unclear how the Home Office can determine that it is impossible or not reasonably practical to even attempt to give notice without trying to do so in the first place. Subsection 40 in brackets 5A seems to allow for no effort whatsoever. Second, the or in subsection 40 in brackets 5a means that the conditions for not requiring notice are severable. Even if it were feasible to give notice, the government would not be obliged to provide notice when any of the concerns under subsection 40 in brackets 5ac are in play. This goes further than the regulation rule alter virus in the D4 case, which allowed for no notice citizenship deprivation only when the person's whereabouts were unknown and there was neither a valid address for correspondence nor a lawyer acting. Moreover, subsection 40 in brackets 5a brackets c creates an exception to the notice requirement for diplomatic or other public interest, not just national security reasons. Basically, they used to have to give you notice, but now they don't. But they're just kind of quoting all the subsections. And yeah. And basically what they're saying, there were certain circumstances where they did have to give you notice, or at least make an attempt. But now, once this amendment gets approved, they don't have to give you notice at all. You can be basically anybody in prison can, or in a detention centre, because that comes under behaviour, public good. Anybody deemed to be misbehaving or not for the public good can be stripped of their citizenship and not even know about it. So these people who, might be in detention centres, might have done something wrong, might have a criminal record, going about their pretty little business, jump on a plane to Africa, America, Jamaica, any part of the Caribbean, ready to come back now. They can't come back. They've been deprived of their citizenship. So, third, what happens after the order is made? The present law explicitly demands notice for the deprivation before the order is made, not after. There would now be no specific requirement in statute that notice need ever be given for a citizenship deprivation order caught by the new amendment. How should the government respond if a solicitor wrote asking them to assist in the repatriation of an individual in the belief that the person was still a citizen? Would the government be obliged to inform the solicitor that they had already taken away that person's citizenship without notice? If there persisted public interest reasons for withholding notice, could the government just say that the person is barred from entry for undisclosed reasons or something to that effect? The likelihood is that the government would elect to specify as a matter of practice that it will eventually give notice. The concern remains that NC 19 may give the Home Office a wide discretion about delaying and even denying information about deprivation of a British citizen, so they don't even have to give a reason. Without knowing they have lost their citizenship, how could the person affected ever appeal? So you just stuck. Dread in a Babylon. Denial of notice and international law. The 1961, I wasn't going to do this, but I might as well read it. The 1961 Statelessness Convention has been signed and ratified by the UK. Article 8 in brackets 4 of the Convention provides for a person being deprived of their citizenship to be given a right to a fair hearing by any court or other independent body. And the editor of Free Movement says, I am not sure whether denying notice before a deprivation order violates the 1961 Convention. but it does stretch the effectiveness of a right to a fair hearing, possibly to breaking point. So it's practically impossible, basically. Conclusion. NC 19 would create an exception to the requirement to always give notice of citizenship deprivation, rather than clarifying the Home Office's powers and correcting judicial meddling. Sometimes it's like a tongue twister. The new clause may end up opening a whole new can of worms. The Home Office is routinely missing its target for issuing new resident permits to people who lose their British citizenship. Figures obtained under the Freedom of Information Act shows. So it looks like they've been depriving they've been depriving British citizenships of their citizenship. These people, for some reason, were not supposed to have their citizenship removed. So they're now applying to the Home Office to have their citizenship reinstated. And the Home Office is taking forever to do it. So do these then people come under the undocumented, illegal category to bump up the numbers? Because if somebody loses their British citizenship, obviously, and they waiting to be reinstated, obviously they've been stripped of their British citizenship erroneously. How can you make a mistake like that? And then they have the nerve to take forever to put it right. I mean, these people it's almost like they just like to make life difficult. They have to make life difficult, don't they? Honestly. Reasons for deprivation of citizenship. So this is from another source. National security, well, we know that. Fraud, like I said. Right, something wrong on the application form or any part of the immigration process or in any criminal proceedings or anything. They gotcha. False representation. Don't pretend you're someone else. You get people with the same name, almost the same name, impersonating other people. You just change the name around, and they do that with their driving license. I'm not going to say who, but you do have a group of people who have their names are very similar, so they misrepresent each other in a lot of different ways. And so that's sometimes when you see people driving and you say, bloody hell, they couldn't have passed their test because they're making obvious errors. That's sometimes why it happens. So this is one, if they get catch now, this is one of the reasons they'll be deported. False representation, pretending you're someone else. Deprivation is conducive to the public good, is non-conducive to the public good. So non-conducive to the public good means it's not desirable to admit the person into the UK based on their character, their conduct, or even their association. So it's not even just you. It's also who you associate with. You know what our parents used to say? Show me your friends and I'll tell you who you are. Because they pose a threat to UK security. This applies to conduct both in the UK and overseas. And then once deported, you can't come back for 10 years. And after 10 years, they're definitely not going to let you in. So that's it. I hope that found it useful. It does sound a bit boring when the word is technical, and I do try to make it simple. But in certain things, I do really have to read it. Because this is not my bag. I'm not an immigration lawyer. I don't have any immigration background. So don't ask me any funny questions. Okay. And remember, always, if you're seeking, seriously though, if you are seeking help with immigration matters, do get an OSIC lawyer. And you can get them from the Law Society, the Home Office, Citizen Advice Bureau, and I'll put the links below. Have a wonderful evening. That's all for now. Bye-bye.